Welcome to your personalized deep dive. Today, we're going to be tackling a topic that's both complex and fascinating: the UK's separation of powers. You sent over some intriguing excerpts from a UK constitutional and administrative law document. And I have to admit, I'm already curious to see how this all plays out.
What makes this particularly interesting is that, unlike the US with its neatly written constitution, the UK system is more, shall we say, organic. It's evolved over centuries, making the separation of powers less about clear-cut lines and more about a delicate balance.
Exactly. So, no easy answers here, but that's what makes this deep dive so intriguing. We're going to explore how this principle actually works in practice, in all its messy glory.
And like any good investigation, we start with a bit of historical context. The idea of separating powers to prevent tyranny goes way back, even before the US was a twinkle in the Founding Fathers' eyes.
Okay, so who are the key players in this historical drama? Give me the Spark Notes version.
Well, we have to start with Viscount Bolingbroke, an 18th century political figure who argued for keeping the crown, parliament, and the people in a state of equilibrium. He saw it as a three-legged stool. Remove one leg and the whole thing collapses.
Makes sense. Balance is key. But I have a feeling there's more to this story. Who else shaped this idea of separation of powers?
That would be Baron de Montesquieu, a French philosopher who was absolutely smitten with the concept. He went a step further than Bolingbroke and argued for a clear division of governmental power into three distinct branches: the executive, the legislature, and the judiciary, each with its own role and the ability to check the others.
Classic checks and balances. So, Montesquieu was all about making sure no single entity could amass too much power. Sounds like a good plan to me. But wasn't he also under the impression that the UK already had a pretty solid separation of powers?
He was, and that's where things get a bit more complicated. Montesquieu saw the UK system as a model of separation of powers, but in reality, even back then, the lines between the legislative and executive branches were already pretty blurry.
Ah, so maybe Montesquieu viewed the UK system through rose-colored glasses. Perhaps he had limited information. Or maybe the UK system itself was already evolving away from that clear-cut separation he admired. Either way, it sounds like his view was a bit idealized.
It seems that way. He was writing during a period when the monarch's power was already waning, and more power was concentrated in the ministry and parliament. This shift may have led him to overestimate the degree of separation that actually existed.
So, a case of it's complicated, even back then. But before we get too lost in the historical maze, let's bring things back to the present. How do modern legal minds define separation of powers?
We can turn to Professor Wade, a legal scholar who provided a clear and concise framework. He argued that separation of powers boils down to three key points.
Okay, Professor Wade, lay it on me. What are the non-negotiables of separating powers?
First, no one person should hold positions in multiple branches of government. No double dipping, so to speak. This helps prevent any individual from accumulating too much power.
Makes sense. Power should be distributed, not concentrated. What's the second point?
Second, no branch should interfere with the work of another. Each branch must operate within its own sphere of authority, respecting the boundaries of the others.
Okay, so no meddling or overstepping. A recipe for institutional harmony, I suppose. And what's the final point?
Finally, each branch should stick to its own functions. The legislature makes laws, the executive enforces them, and the judiciary interprets them. No blurring the lines or trying to wear each other's hats.
So, a clear division of labor, with each branch playing its designated role. Seems straightforward enough on paper, but we already know that the UK system isn't quite that black and white.
Precisely, and even top UK judges have acknowledged this. Lord Diplock, for instance, stated that the UK Constitution, while unwritten, is still firmly based upon the separation of powers. He emphasized Parliament's role in making laws and the judiciary's role in interpreting them. Lord Stein echoed this sentiment, calling separation of powers a strong principle of the UK system.
So, it's not that separation of powers is absent in the UK. It's just not as pristine and absolute as some might imagine. More like a dance with overlapping steps and carefully choreographed checks and balances.
A very apt analogy. We could call it a partial separation,
Earlier.
where there's some intentional overlap between branches,
Yeah.
but with safeguards in place to prevent any one branch from becoming too dominant.
Okay, so it's a balancing act, not a strict separation. And now I'm really curious to delve into the specifics. Where do we see these overlaps and checks in action?
Well, let's start by examining the relationship between the executive and legislative branches. This is where things get really interesting. With personnel overlaps, that might surprise you.
Bring on the intrigue. I'm all ears. What kind of overlaps are we talking about?
In the UK system, Ministers, including the Prime Minister and the Chancellor of the Exchequer, are drawn from the legislature, in fact.
Hmm.
The Prime Minister and Chancellor are required to be members of Parliament.
Hold on. So the people running the government are also part of the body that makes the laws. Doesn't that seem like a bit of a conflict of interest? It's like being both the pitcher and the umpire in the same game.
You've hit on a point that has generated considerable debate. Lord Hailsham, a former Lord Chancellor, even went so far as to call this setup an elective dictatorship, arguing that the executive could potentially dominate the legislature, especially if one party has a strong majority in Parliament.
Elective dictatorship. That's a powerful phrase. What do you think, listener? Does that term accurately reflect the UK system, or is it a bit too dramatic?
It's certainly a thought-provoking label.
Yeah.
And it's not just about the individuals. There are also functional overlaps between the executive and legislature. For example, the UK government has the power to create what's called secondary legislation.
Secondary legislation. Break that down for me. What does that mean in practical terms?
Think of it this way. Parliament passes a broad law, setting out the general principles and objectives. Secondary legislation allows the government to create more specific rules and regulations within the framework of that broader law.
So, the executive branch gets to fill in the details, adding a layer of specificity to the laws passed by Parliament. That sounds like a lot of power delegated to the government.
It is, and it can raise concerns about accountability. There are even more controversial mechanisms, like the infamous Henry VIII clauses.
Henry VIII clauses. Now that sounds like something out of a history book, and maybe not the most democratic chapter. What are these clauses all about?
Well, these clauses allow the government to actually change acts of Parliament without needing full parliamentary approval.
Whoa. That seems like a direct challenge to the balance of power. It's almost as if the executive branch is saying, thanks for the law, Parliament, but we'll tweak it as we see fit.
It definitely raises eyebrows in terms of parliamentary sovereignty and democratic process. Critics argue that it gives the executive excessive power to alter legislation without proper scrutiny.
Okay, so we've seen how the lines between the executive and legislature can get blurry, with some potentially worrying implications for power balance. But I'm guessing this isn't a one-sided story. What about those checks and balances you mentioned earlier? How does Parliament keep the executive branch from running amok?
Parliament has a whole arsenal of tools at its disposal to keep the executive in check. One of the most powerful is the vote of no confidence.
Ah, yes, the political equivalent of a thumbs down. So if the government loses the confidence of Parliament, what happens? Does everyone just pack up and go home?
Not quite. But it's definitely a major shakeup. If the government loses a vote of no confidence, the Prime Minister is expected to resign. And it can trigger new elections. It's a powerful deterrent against executive overreach.
So the threat of being shown the door keeps the government on its toes. What other mechanisms are in place?
Well, there's Her Majesty's Loyal Opposition, a formal group in Parliament whose very purpose is to hold the government accountable. They scrutinize policies, debate legislation, and generally make the government's life a bit more challenging.
I like it. A dedicated team of challengers, always ready to poke holes in the government's arguments. Seems like a healthy dose of skepticism is built right into the system.
Exactly. It ensures that different perspectives are heard, and that the government's actions are subject to rigorous debate. And then we have question time, a lively spectacle where ministers have to answer questions from MPs, often on the spot.
I've heard about question time. It sounds like a political version of a rapid-fire Q&A session. Do the ministers ever get stumped?
It definitely happens. It's a chance for MPs to hold ministers accountable for their decisions and to demand clear explanations. And if a minister fumbles a response, it can become quite the news headline.
Gotta love that transparency. So between opposition, question time, and the ever-present threat of a no-confidence vote, it sounds like Parliament has a pretty good handle on keeping the executive in line. What other tools do they have in their toolbox?
Parliament also relies on select committees, specialized groups that investigate specific issues and hold hearings where ministers and other officials have to testify and answer questions. These committees provide in-depth scrutiny and can produce reports that influence policy decisions.
So it's like having a team of investigative journalists embedded within Parliament, digging deep and shining a light on potential problems. Pretty impressive.
It is. And we can't forget the House of Lords, which, though unelected, plays a vital role in scrutinizing the government's actions and proposing amendments to legislation. While its power is more limited than the House of Commons, it has another layer of checks and balances to the system.
Okay, so we've explored how the executive and legislature dance this intricate tango, with overlaps, checks, and balances woven into their relationship. But what about the other pairings? What about the interactions between the executive and the judiciary? That's always a fascinating dynamic.
It is indeed. And as we delve into this relationship, we'll encounter those same themes of overlap and checks that we've seen before. For instance, let's consider the role of the Attorney General.
The Attorney General. Refresh my memory on what their role is in the UK system.
The Attorney General serves as the government's chief legal advisor. But here's the twist. They're also a member of the government, often a cabinet minister.
Wait, so they're advising the government on legal matters, while also being part of the government. Isn't that a bit like being both the lawyer and the client? It seems like a recipe for blurred lines and potential conflicts of interest.
You're spot on. That dual role has been a source of debate, with some arguing that it undermines the independence of the Attorney General, after all. Can they truly provide impartial legal advice while also being a member of the government they're advising?
It's a tricky situation, for sure. Are there any other areas where the executive and judiciary overlap in a way that raises eyebrows?
Another interesting area is the practice of judges chairing public inquiries. These inquiries are often set up to investigate major events or controversies, and they can have significant political implications.
So you're saying judges are sometimes asked to step out of their traditional courtroom roles and delve into potentially sensitive political issues. That sounds like a delicate balancing act.
It is. Take, for instance, the Leveson Inquiry, which examined the culture, practices, and ethics of the British press. This inquiry was chaired by Lord Justice Leveson, a senior judge.
So in that case, a judge was tasked with investigating a matter that had huge political ramifications. I can see how that might raise concerns about the judiciary getting too close to the political realm and potentially compromising their perceived impartiality.
Exactly. It's a sensitive area. Critics argue that such involvement can blur the lines between the judiciary and the executive, and even raise questions about the judiciary's ability to remain impartial in future cases related to the subject of the inquiry.
It's a reminder that maintaining the perception of judicial independence is just as crucial as maintaining the reality of it. But how does the UK system ensure that the judiciary can still act as a check on the executive, even with these overlaps?
One of the key mechanisms is judicial review, the power of the courts to review actions taken by the executive branch and determine if they are lawful.
So the courts can essentially step in and say, hold on, government, that decision you made, it doesn't square with the law.
Precisely. It's a fundamental check on executive power, ensuring that the government doesn't overstep its legal boundaries. A landmark case that solidified the principles of judicial review in the UK was the GCHQ case in 1985.
GCHQ, that rings a bell. Remind me what that case was all about.
GCHQ stands for Government Communications Headquarters, the UK's intelligence and security organization. The case revolved around the government's decision to ban trade unions at GCHQ, citing national security concerns.
So a pretty high-stakes situation with national security at the forefront. What was the outcome of the case?
The court ultimately ruled that while national security was a legitimate concern, the government's actions in this case were unlawful because they hadn't properly consulted with the affected trade unions before implementing the ban.
Interesting. So the court recognized the importance of national security, but also upheld the principle of fair process. They basically told the government, even in matters of national security, you still have to follow the rules.
Exactly. It reinforced the idea that no one, not even the government, is above the law. And it demonstrated the power of judicial review to hold the executive accountable.
This deep dive is really highlighting the intricate dance between the different branches of government, with each one pushing and pulling to maintain a delicate equilibrium. It's clear that separation of powers in the UK is less about strict boundaries and more about a constant negotiation of power, with checks and balances acting as safeguards against overreach.
Well said. And as we move on to explore the relationship between the legislature and judiciary, we'll see even more examples of this delicate dance in action.
I'm eager to see what we uncover next. But before we jump into that, let's make sure our listener is keeping up. What are some key takeaways you want them to remember about the relationship between the executive and judiciary in the UK?
The main takeaway is that even with these overlaps, the UK system has robust mechanisms to ensure the judiciary can act as a check on executive power. Judicial review, as we saw in the GCHQ case, is a powerful tool that prevents the government from acting beyond its legal authority.
Right. Even when national security is invoked, the courts can step in and say, hold on, you still have to play by the rules. It's a reassuring reminder that no one is above the law. But now I'm really curious to dive into that last relationship we need to unpack, the legislature and the judiciary. We touched on this briefly in the previous parts, mentioning the historical overlap of the House of Lords serving as both a legislative body and the highest court.
Ah, yes. A situation that certainly muddied the waters of separation of powers. For centuries, the same individuals were responsible for making laws and delivering final judgments on legal cases. Talk about a potential conflict of interest.
It boggles the mind. It's like being the playwright and the theater critic at the same time. You'd be tempted to give your own play rave reviews. But you mentioned that the UK eventually addressed this rather glaring issue.
They did. In 2005, the Constitutional Reform Act brought about some significant changes, including the creation of a brand new Supreme Court of the UK. This new court took over the judicial functions that were previously handled by the House of Lords.
Okay, so they finally disentangled those judicial powers from the legislative branch. That seems like a huge step toward a clearer separation of powers. It's like they finally recognized that it's not a good idea to have the same people writing and interpreting the rules of the game.
Exactly. It was a major development in the UK's constitutional journey, reinforcing the principle that judging and legislating should be distinct functions. But even with that separation, there are still some fascinating areas where the legislature and judiciary intersect. One intriguing example is parliamentary privilege.
Parliamentary privilege. Now that sounds familiar. Remind me what that entails and how it fits into the separation of powers puzzle.
Parliamentary privilege is a set of special rights and immunities that protect Parliament from outside interference. It allows Parliament to regulate its own internal affairs and conduct its business without being subject to the normal laws of the land.
So Parliament gets to make its own rules, and no one can question them. That sounds like a lot of autonomy.
It is. Parliamentary privilege is a cornerstone of the UK system, rooted in the idea that Parliament must be free to debate and legislate without fear of external pressure or legal repercussions. It ensures that MPs can speak freely and scrutinize the government without fear of being sued or prosecuted for what they say.
It makes sense that Parliament needs some level of protection to function effectively. But are there any limits to this privilege? Could they, for example, decide that it's okay to, I don't know, wear pajamas to Parliament and declare it a no-suit zone?
Well, while the pajamas might be a stretch, parliamentary privilege is not absolute. It has been defined and refined through centuries of legal precedent, and the courts have occasionally stepped in to clarify its boundaries. The key point is that it's intended to safeguard Parliament's core functions of debating and legislating, not to give MPs carte blanche to do whatever they please.
Okay, so it's a powerful tool, but one that's not entirely without limits. Checks and balances at play once again. But I'm also thinking about another key aspect of this relationship. Judges are supposed to interpret the law, not make it.
Right.
That's sort of the bedrock principle of a judiciary in a democracy.
You're absolutely right. That's the ideal scenario. But in practice, the line between interpretation and lawmaking can sometimes get a bit blurry, especially in a common law system like the UK, where judicial precedent plays such a significant role.
So are you saying that UK judges sometimes venture into lawmaking territory? I'm all ears.
It's a debate that has kept legal scholars busy for generations. One case that often comes up in this discussion is RVR from 1992. This case involved a husband who was convicted of raping his wife.
Okay, I'm following so far. But what makes this case so significant in the context of separation of powers?
Well, at the time, there was a legal exemption in English law that essentially said husbands couldn't be guilty of raping their wives. It was a relic of a time when women were viewed as property rather than individuals with equal rights.
Wow, that is truly archaic and appalling. So what happened in the case? Did the court uphold this outdated exemption?
No, they did not. The House of Lords, which was still the highest court at the time, overturned that centuries-old exemption. They declared that it was no longer a part of English law, recognizing that it was incompatible with modern notions of equality and human rights.
So they essentially changed the law through their interpretation. That's a pretty bold move. I can see how this would spark debate about whether the court was simply interpreting the law or actually making new law.
Exactly. The RVR case is a prime example of how judicial interpretation can have a profound impact on the law itself, pushing it to evolve and adapt to changing societal values. Some argued that the court had overstepped its bounds and engaged in judicial activism, while others praised the decision as a necessary and long overdue correction of an unjust law.
It's a fascinating example of the tension that can sometimes exist between respecting the legislature's role as the primary lawmaker and recognizing the judiciary's role in ensuring that the law is applied justly and in accordance with evolving social norms.
Precisely. It highlights the complexities of the UK's separation of powers, where those lines are not always perfectly clear. And this tension becomes even more pronounced when we consider the impact of the Human Rights Act of 1998.
Ah, yes, the Human Rights Act. That was a landmark piece of legislation, wasn't it? It essentially brought the European Convention on Human Rights into UK law.
Right. That's right. The Human Rights Act incorporated the Convention rights into UK law, giving them domestic legal force. And this created some new and interesting dynamics in the relationship between the legislature and the judiciary.
I bet. Give me the highlights. How did the Human Rights Act change the game?
Well, one of the key provisions of the Act, Section 3, requires UK courts to interpret legislation in a way that is compatible with the Convention rights, so far as it is possible to do so.
So if a law seems to clash with those fundamental human rights, the courts can't just ignore it. They have to try to find an interpretation that aligns with the convention.
Exactly. It's a powerful tool that empowers the judiciary to uphold human rights standards, even when faced with legislation that might seem to infringe upon those rights.
It sounds like a deliberate attempt to ensure that human rights are embedded within the very fabric of UK law. But what happens if a court finds that a law is simply incompatible with the convention rights? Can they just strike it down?
That's where Section 4 of the Human Rights Act comes in. If a court determines that it's impossible to interpret a law in a way that is compatible with the convention rights, it can issue what's called a declaration of incompatibility.
A declaration of incompatibility. That sounds pretty serious. What are the implications of such a declaration? Does it invalidate the law?
Not exactly. It's more of a signal to Parliament, saying, we've got a problem here. This law needs to be looked at because it appears to violate fundamental human rights.
So it's like a red flag raised by the judiciary, prompting the legislature to re-examine the law in question.
Precisely. It's a mechanism that preserves parliamentary sovereignty. Parliament still has the ultimate authority to change or amend the law, but it also gives the judiciary a powerful voice in upholding human rights standards within the UK legal system.
It's another example of that delicate dance we've been talking about. The courts can highlight issues, but ultimately, it's up to Parliament to take action. But this whole process of interpreting legislation through the lens of human rights, doesn't it give judges a lot of power? Some might argue that it allows them to shape the law in ways that go beyond their traditional role as interpreters.
That's a valid point, and it has been a subject of much debate. Some see it as judicial overreach, while others view it as a necessary safeguard against human rights abuses. Lord Stain, a prominent UK judge, famously said that this type of interpretation requires courts to go beyond the niceties of language and consider the broader context and purpose of the law.
Beyond the niceties of language. I like that. It suggests that judges are being asked to be more than just literal readers of the law. They have to be creative interpreters, sensitive to the spirit and intent of human rights principles.
Exactly. They must grapple with the complex interplay between legislative intent, legal precedent, and evolving human rights standards. And in doing so, they inevitably shape the evolution of the law.
This deep dive has been a revelation. It's amazing how the UK system, with its unwritten constitution and centuries of tradition, has managed to create a framework for separation of powers that is both complex and surprisingly resilient.
It's a testament to the UK's capacity for adaptation and its commitment to the rule of law. The system is constantly evolving, reflecting the changing needs and values of society.
But before we wrap things up, there's one final element I want to touch upon. Remember how we talked about the monarch being the head of state?
Ah, yes, the crown, an enduring symbol of the UK's history and traditions.
Well, it turns out the monarch is technically the head of all three branches of government: the executive, the legislature, and the judiciary.
That's right. The monarch is simultaneously the head of state, the head of the executive branch, the supreme governor of the Church of England, and, in a sense, the embodiment of the judiciary. It's a remarkable concentration of roles in a single figure.
It's like they're the ultimate multitasker, wearing all these different hats. But with all this talk about separation of powers, how does this even work? Is the monarch secretly calling all the shots?
Not quite. In reality, the monarch's role in the UK system is largely ceremonial and symbolic. They act on the advice of their ministers and don't directly exercise these powers in any significant way.
So the monarch is more of a figurehead than an actual ruler, a symbol of continuity and national unity rather than a wielder of real political power.
Precisely. The real power lies with the elected government and Parliament. As we've seen throughout our deep dive, the monarch's role is to advise, counsel, and warn. But ultimately, the decisions rest with those who are directly accountable to the people.
It's fascinating how the UK has managed to blend these ancient traditions with a modern democratic system of government. It's definitely not your typical separation of powers setup, but it seems to work, albeit in its own quirky and fascinating way.
Absolutely. The UK system is a unique blend of history, pragmatism, and a deep respect for the rule of law, and it continues to evolve, adapting to new challenges and societal shifts.
And that brings us to the end of our deep dive into the UK's separation of powers. We've explored the intricate relationships between the branches, uncovered historical quirks, and pondered the enduring role of the monarch.
We've seen how overlaps and checks are woven into the fabric of the system, creating a dynamic balance that protects individual liberties and ensures accountable government.
Exactly. It's been a whirlwind tour through a complex but fascinating system, one that reminds us that separation of powers is not about rigid boundaries, but about a constant negotiation of power, guided by principles of fairness, accountability, and the rule of law.
And as always, we want to leave you with a final thought to ponder. The UK's system is a work in progress, always adapting to new realities. Do you think these reforms, especially the creation of the Supreme Court and the incorporation of human rights law, have brought the UK closer to the ideals of separation of powers? Or are there still areas where the balance could be improved? It's a question worth considering as the UK continues to navigate the complexities of its constitutional arrangements in the 21st century.
Thanks for joining us on this deep dive. We hope you've learned something new, gained a deeper appreciation for the UK's unique system, and maybe even sparked some lively debates of your own. Until next time, keep exploring, keep questioning, and keep diving deep.